Good morning, friends. We are going to discuss an instance of delay of 1016 days in filing the appeal by the revenue officers. You may be knowing the Limitation Act from 1963 is there. It is actually for the purpose of the stopping or putting an end to the litigation at certain level. Otherwise, after 20 years, after 30 years, people are going to file the cases. Of course, there are certain leverage also, even though Section 9 of the Limitation Act says that once the limitation starts running, it will run to just like our promissory note 3 years. But according to Section 5, if you are the prescribed period will be extended. That means the condonation of delay will be accepted when if the appellant is able to satisfy the court that he has a sufficient cause for not preferring the appeal or making the application within such period. Otherwise, any application definitely may not be allowed. So Section 5 is the important section. Of course, there are so many instances where people take advantage. Directly we can say the court is also considerate. So many instances. Previously I have seen an incident where 3406 days of delay was accepted in a certain case. 3406 of days. Delay of 3406 days. Application by plaintiff for declaration. So definitely there are certain conditions. Right. Now, please remember the calculation of time. Normally 30 days or 60 days period will be there to appeal. Right. If you go into the case, details you will be better able to appreciate. This happened in Mangalagiri, almost the present capital of situated near the present capital of AP. So the Honorable Justice Sri Pattu Devanand of AP High Court came down heavily on Tahsildar Mangalagiri for filing an appeal with a delay of 10-16 days. It is the second appeal and imposed a fine of rupees 25,000 on him and also actually dismissed the main appeal also. The facts of the case are like this. There is land, it belongs to Padmashali Sangham. Actually, a Padmashali woman by name Damarla Nancharamma. She has donated 7 acres of land in Mangalagiri for the Padmashaliya Bahuttama Sangham for the development or for the welfare of the Sangham. So they wanted actually to construct a tank in the area because Mangalagiri at the time it was not having enough storage of water. They wanted to construct a tank. But the time went on and ultimately now the encroachers or so many people have encroached the area. 3 acres have gone. Out of this 4, out of the 7, 3 acres were encroached by so many persons. It is very difficult to remove them from that place. Right? Now, at least they wanted to fence the 4 acres of land in 2011. They have decided to erect fencing to the rest of the land in order to protect the same. So, while they were about to do the fencing, the revenue authorities gave notices to them stating that this land is vested with the government of AP and not theirs. Finished. The litigation started. Immediately, they approached the junior civil judge Mangalagiri and filed an original suit. So, for the declaration of the title and other things, ultimately, they were not successful. In 2012, the judgment came against them. Then the Padmashaliya Bahuttama Sangham, these people, they have gone in appeal, and in the appeal during the year 2015, the court gave orders favorable to this Padmashaliya Sangham. That means they can enjoy the land. Now, first appeal, now you may be knowing there's a provision for the second appeal in CPC. Now, actually, the government, that is the revenue department, they are supposed to file an appeal. When maybe after 60 days after 2015, after taking judgment copy, so many things will be there. Right. Now, ultimately, very recently, the Tahsildar Mangalagiri he has filed the appeal. Right? The matter came before the Honorable Justice Bhattu Devanand, and after seeing the same, actually it was averred in the petition that delay. Of course, he has filed the appeal. At the same time, he has filed a petition for condonation of delay according to Section 5 of the Limitation Act. Right? He has stated a request to the Honorable Court that the delay of 699 days may be condoned. But the other side lawyer, he has brought to the notice that actually there was a delay of 10-16 days. Now, immediately Justice Devanand, he has taken very serious view of the matter. And of course, even though in the condonation petition, the Tahsildar stated that they were busy with the land pooling work and other things, then he has come to the conclusion that this shows the lack of sincerity towards the government officers. No doubt, if it is 1 month, 2 months, it have been they have accepted. Even nowadays, even though Section 9 is there, 3 years period is over in a promissory note case, because of the Corona, High Court has given orders to take up the matters also, even after the pretty is over. But the delay of 10-16, almost 3 years, is intolerable. They cannot accept. Ultimately, he has imposed a fine of 25,000 rupees, ordered it to be collected from the concerned authorities who are negligent. Normally what they say, this Tahsildar says we have to consult the GP. GP says I have to give opinion to the collector. Like that, so many intricacies because of the procedural wrangles will be there in the government authorities. So Justice said that whoever is negligent, who is responsible, fix the responsibility and let them pay 25,000 rupees. Is one part. Normally the court says you pay the fine and admit the appeal, but he has not admitted the appeal also. The appeal also dismissed. So what is the use of filing the same after so many years? Isn't this unnecessarily putting the other party under embarrassment like it? So if you wanted to file the challenge, the verdict, you would have challenged it after 2 or 3 months itself, even though 60 days you are supposed to do. But you have to, without doing the same, sleeping over the matter for so many years, and now coming to the court and filing the same is actually absurd and not acceptable also. Of course, previously the Supreme Court allowed the so-called 3406 days. There were normally the circumstances, the facts and circumstances should be able to satisfy the court. Of course, if the court is satisfied, okay. They have, in the case of Government FFE Municipal Administration and Urban Development Department versus M.A. Razak and others, 2004, the High Court has allowed 257 days of delay. So normally, because they know the procedure of government procedures, definitely there will be so many delays, so many hitches also. Normally they will accept, but this is too much. Sufficient cause they could not. You should explain and you should give the sufficient cause. If you don't give the sufficient cause, this is the result. So, my dear government officers, please be careful while filing the appeal. This applies to every government officer. See how bad it is getting so-called strictures from the High Court judge and saying that, and the main point is the original petition, the original second appeal was also dismissed. Suppose if it is not there, we could have some satisfaction. It is also gone. So please be careful in such instances and don't repeat such mistakes. Thank you.